I haven't had much to say about this case prior to today because I didn't feel it was appropriate to do so until today. Ms. Hildebrandt, my client, has pled guilty today to 4 counts. She has done so because she takes responsibility for her conduct in this matter. Her guilty pleas, she decided to plead guilty before Ms. Franke entered into her plea agreement or agreed to cooperate with the state. She has pled guilty because she did not want these children to have to testify. She takes responsibility. And it is her main concern at this point that these children can heal, both physically and emotionally. We look forward to sentencing. That's all I have to say today.
There are people all over the world that are coming out and saying that Jodi Hildebrandt has destroyed families, that she has hurt a lot of people. Has she seen this kind of the backlash that's happening, and what does she have to say about it?
I'm not going to have any more comment, nor is she, at least prior to sentencing. Thank you.
When will the sentencing take place?
February 20th. Thank you.
In terms of the agreement, as far as how that pertains to sentencing, and is there a specific range that the court has agreed to?
She's agreed to a prison sentence, 4 counts, consecutive, the same as Ms. Franke. Exactly the same as Ms. Franke.
In Utah, there's rumors about consecutive sentences. How long could her sentence term be then? Could all 4 be consecutive together?
Ultimately, it's up to the Utah Board of Pardons, and I'm not going to speculate at this point how long she might serve. Thank you.
I'm Washington County Attorney Eric Clark, and I just have a brief statement that we'll read, and then we'll be happy to release this along with the signed plea agreement to anybody that requested today. So this morning, Jodi Hildebrandt pleaded guilty to 4 counts of aggravated child abuse. She will remain incarcerated, awaiting sentencing, which will occur on February 20th, 2024. As part of the plea agreement, Ms. Hildebrandt agreed to be sentenced to consecutive, as opposed to concurrent, prison terms for each of the 4 counts. One of the toughest things we ask victims of alleged abuse to do is testify in a trial against their abusers. We are pleased that in this case, and in Ms. Franke's case, that won't be necessary, that both defendants will be going to prison without having to hold a trial. We're grateful to the multidisciplinary team that investigated this case. We have great law enforcement officers, caseworkers, Children's Justice Center staff, both in our area and in Utah County. Additional information about Ms. Hildebrandt and Ms. Franke's cases, including redacted investigative materials, will be available upon request 30 days after sentencing of both defendants. For further information, please refer to the statement of defendant in support of guilty plea that was filed with the court this morning, and we'll be happy to make that available. Thanks, you guys.
Why were 2 of the counts dismissed?
So, in any plea agreement, there's always some back and forth in that, and in this instance, 2 counts were dismissed, and what Ms. Hildebrandt agreed to do was to not contest that for each of the terms that we prison, and that those run consecutive as opposed to concurrent.
But why not all 6?
Well, so I think that's a fair question, and that's what, as a prosecutor, that's what you deal with every time you're handling a case, right? Is if our plea offer had been there is no plea offer, plead straight up to all 6, then the defendant has no incentive to go to trial. And we're not afraid of trials. We don't want to avoid trials. Trials carry some risk in that you don't know what the outcome's going to be, but more so when you have victims that are having to go through the trial process, that's difficult. And so if we can get a result that is similar, in Utah, there's the maximum penalty for second-degree felonies is 30 years. So if we had 15 counts, the maximum amount of time would have been 30 years. And each count carries a 1 to 15 years. So the difference in reality between 4 counts and 6 counts, in our calculation, wasn't enough to justify asking victims to go through a trial.
part of Ruby Franke's plea deal was to testify against Jodi Hildebrandt. That was like a big part of that plea deal. Does that mean that is irrelevant now? She will not have to testify against Jodi?
That's what I anticipate, yeah.
When it comes to prosecutors always have to determine who they think is the more culpable party in co-defendants. Who do you believe is the more culpable party?
I'll be more comfortable speaking about specifics in the cases after sentencing, and then we wait for the 30 days to make sure that appellate time is run. And that's just us being super careful to make sure that procedurally we're not doing anything that could complicate a case down the road and overturn a conviction. So I'm not going to get into thought processes at this point.
In yellow with KSL 5 News, the defense attorney said that Hildebrandt chose to plead guilty before Ruby Franke made the decision to plead guilty. Is your office aware of the timeline there in which plea happened first? Which agreement happened first?
No, in that we weren't talking to both Hildebrandt and Franke, right? It was clear to us we knew that Franke was going to plead earlier than Hildebrandt. Thus, like Franke's the deal that Franke pled to included her agreeing to testify against Ms. Hildebrandt, and also that we would not submit things to the parole board asking that she stay in prison for a longer term. So that was in Franke's plea. That's not in the paperwork that you guys will see for Hildebrandt's plea.
In Frankie's case, you agreed to stay neutral for parole board hearings. Did the same agreement happen with Hildebrandt or no?
No.
So there's I know we can't predict the future, but so the door is open for the Washington County Attorney's Office to go to Hildebrandt's parole hearings and say, we believe she needs to stay in. Okay.
That's a good question. So the answer to that is yes. More commonly, the prosecutor's office can submit a letter or submit things in addition to the pre-sentence investigation of my declaration parole. But there's always the option of actually going in person and being in those hearings also.
Aggravated child abuse in Utah is a second-degree felony. Do we need to look at these laws in Utah?
I hope so. And that's something that I've been in talks with legislators already about.
Thank you.
Is that as a result of this case?
Like I said, I don't want to get into my thought process on this case until we're further along. But I have been talking to some of our legislators that are open to criminal justice reforms about the level of severity in Utah law.
When did those conversations start?
In the last few months. Thanks, you guys.
As far as child abuse cases, where does this one rank in your career?
I'm not going to get into, I'm not going to get into my personal thoughts on this until we know that everything is done in the appellate time is right. Thanks, you guys. Have a great rest of your holiday
Thank
break.
you.
Thank you. Thank you so much. How do we get the documents